All right, I think we're good to go. Good evening, everybody. Thanks so much for bearing with us. We've got a Facebook live stream going simultaneously, so we have a wider audience than just is here with us on this Zoom. I'm Mallory. I work with the Housing Development Consortium, and we are so grateful that you were able to take time out of your evening to join us for this Tenants' Rights Know Your Rights workshop hosted by the Eastside Legal Assistance Program. HDC hosts an Affordable Housing Week annually, and we are pleased that we were able to transition to this virtual format. However, it's a little bit unusual for us all. So thanks for being here. We have a lot to cover, and we've got some experts that are going to help us understand what protections are currently available for both at the local level, the state level, and also the federal level as far as eviction moratoriums go, and other insights that are really important for renters in our state and in King County. I'm going to pass it over to Chris Lovings with Eastside Legal Assistance Program now to introduce our presenters for this evening.
Hey everyone, good evening. Thank you so much for joining us today. We appreciate you being here with us to kind of learn and hear more about what's going on with tenant rights currently. So let me back up really quickly. My name is Chris Lovings. I work as a community engagement manager for Eastside Legal Assistance Program. Our organization's whole goal is to make the legal system more accessible to those most in need. We do that through a variety of ways: legal clinics, we have housing stability attorneys that you're going to be hearing from in a little bit. We have a domestic violence program that connects domestic violence survivors with legal help to help them out with their situations. And a lot of the work that we're also doing during this time has been Know Your Rights sessions, where we talk about different topics that are relevant in civil legal aid. We've done some before on Social Security, public benefits, and many around immigration. And last but not least, of course, tenant rights. And that's kind of why we're here today in the form of this webinar. So I want you to sit back and enjoy yourself. As we're going along, feel free to type any questions in the chat. We'll be sure to answer them at our Q&A session on the back end of this. But without any further ado, I'm going to introduce us to our two speakers tonight. So first up is Catherine Knighton. She is ELAP's Housing Stability Program staff attorney. She provides advice and representation to low-income residents of South King County who face a civil legal issue that threatens their housing stability. Catherine obtained her JD from the University of Washington School of Law, where she focused on public defense and disability. Catherine joined ELAP in August of 2020, and through her work, she hopes to help support safe and stable housing for all, which is crucial to thriving communities. Our second speaker is going to be Shane Warner. He/him is a staff attorney responsible for ELAP's Kirkland-focused housing stability program. Shane provides advice and representation to residents of Kirkland who are facing a legal issue that threatens their housing stability, primarily in the area of landlord-tenant law. Shane obtained his JD from the UW Law School and began his career as a frequent volunteer attorney at the Housing Justice Project. It was there that he developed his passion for housing issues and defending the rights of tenants. He joined ELAP in fall of 2019. We're going to pass it over to Shane and Catherine. Once again, thank you all so much for being here.
All right, hi everybody. I'm gonna kind of kick things off here. Thank you, Chris, for that intro, and Mallory as well. And I just want to give a special thanks real quick to Mallory and Emma and everyone else at HDC for helping us put this on tonight and letting us be part of one of the many awesome events going on for Affordable Housing Week. So with that said, I am going to go ahead and share my screen because we've got a PowerPoint that we just want to go through as we're kind of walking through the various levels of protection that are available to Washington tenants. Okay, that is a little bit ahead of where I wanted to be, so I'm going to back up in just a second here. All right. Okay, now at the beginning of the actual presentation, I am going to start off with some just general comments before we begin. Now, obviously, this webinar is just going to be designed to provide general information about what tenant protections are in place, especially ones that are related to the COVID-19 pandemic. It's not meant to address any specific individual case. The webinar does not create an attorney-client relationship between myself and Catherine or any of the participants. If you do have specific legal questions, or if you feel you need legal advice, then we would urge you to contact a legal aid provider. We'll be giving you some links and some information on what organizations might be available for you to reach out to. So getting into sort of the meat of the law, when we think about what laws protect tenants in Washington, you kind of can look at it as 3 tiers of sort of jurisdiction. The baseline sort of floor is set at a federal level. And at that level, we have an order that was published by the CDC on, I believe, September 4th, that establishes a nationwide eviction moratorium. And then sort of above that, we have our statewide Washington eviction moratorium. And then in some cities, you have city by city cases where the city council may have enacted certain ordinances or laws that create even additional protections above that. So an example would be cities that have passed just cause ordinances, things like that. So I want to kind of quickly go over the basics of the CDC moratorium. By and large, the tenant protections in Washington are created by our statewide eviction moratorium when it comes to COVID-related protections. But like I said, this order was published on September 4th, banning residential evictions throughout the country. It does not apply in states that already have in place a moratorium that provides equal or greater levels of public health protection. So when we're asking ourselves, does this apply in Washington? Maybe it does, maybe it doesn't. There is one scenario in particular where it might apply. For the most part, the protections that we have under the governor's proclamation are stronger than what's provided by the CDC eviction moratorium. There is a possible exception when it comes to 2 of the exemptions in the statewide moratorium. So to kind of explain that, I want to explain that without getting too far ahead of myself, but basically the state moratorium does allow landlords to terminate a tenancy after they've given 60-day written notice of an intent to either sell or occupy a property. The CDC moratorium, on the other hand, does not include the ability to just issue a no-cause eviction like that. So what does the CDC moratorium focus on? Primarily non-payment evictions, which means that federally tenants can still be evicted if they violate other provisions of their lease agreements. However, that does not include just a simple no-cause termination. So without getting too far into the weeds, what that basically means is that there is a legal argument that you could make that the exception in the governor's statewide moratorium violates the CDC moratorium insofar as it allows tenants to be evicted without cause, given those 2 exceptions that I mentioned. And I should also note, as it shows on the slide, that moratorium is set to expire December 31st. coincidentally the same date as the state moratorium, which has just recently, very recently been extended, but we'll get into that. So I do want to point out that the protections of the CDC moratorium are not automatic. The tenant does have to take action before they can be protected under that moratorium. The CDC, along with the order, published a declaration form that tenants must fill out, or they must sign it, and it's signed under penalty of perjury, and then they must provide their landlord with a copy of that form in order to be protected under the federal moratorium. So in order to gain these protections, you have to certify that the qualifications listed on this slide apply to you and your family. So those being that you have done your best to obtain all available government assistance for rent or housing, and that your income will either be no more than $99,000 for a single filer or $198,000 if you file jointly. Alternatively, that you were not required to report income to the IRS for 2019. And then finally, you also are qualified under that portion if you received a stimulus check under the CARES Act. In addition, you also need to be able to certify that you cannot pay your full rent due to a loss of household income, work hours or wages, or that you were laid off, or that you suffered extraordinary out-of-pocket medical expenses. You also need to be able to certify that you're making best efforts to make timely partial payments as much as you can afford, taking into account other non-discretionary expenses. And then finally, you need to be able to certify that if you were to be evicted, you would likely become homeless. You would need to move into a homeless shelter, or you would need to move into a shared residence. So I think I would caution tenants or folks working with tenants to consult with an attorney prior to signing this declaration. Like I said, it does have to be certified, signed under penalty of perjury. So if you cannot genuinely claim to qualify for each of these, there could be some legal risk there. So I think if this is a declaration form that you're thinking of filling out and giving to your landlord, it will be wise to consult with an attorney first. And like I said, as we get further into tonight's presentation, we'll provide some names of organizations and links who might be able to help with that. So as I kind of went over very briefly, it seems like just from looking at the state moratorium versus the federal moratorium, the Washington statewide moratorium gives a lot more protections. I mean, you can't be, as Catherine will explain, you can't be evicted under our state moratorium for those additional violations of the leases like you can under the CDC moratorium. The reason why it may still be relevant to Washington tenants is, like I said, you can conceivably make an argument that the 60-day notice to occupy or sell rental property that is built into our state moratorium is a lesser protection than what's provided by the CDC order. So this is definitely something that you would want to talk to an attorney about, because there's a lot of uncertainty over how a court would actually rule on this. This is a brand new issue. Obviously, the order was published a little over a month ago. I have personally heard, I've heard it turn out in the tenant's favor. I've heard it turn out in the landlord's favor. So there's a very big question mark there over whether a court would agree with that argument, or whether it would just be a blanket decision of no, the state moratorium provides greater protection, so it applies across the board. So it's just something I wanted to cover briefly, point out, and just, I guess, emphasize that be aware that this protection is here, but if at all possible, it would be to your benefit to speak with an attorney first to see if it applies to your situation. So having gone over that, I'm going to pass things off to Catherine, and she's going to start going sort of in detail on the protections afforded in the statewide moratorium.
Awesome. Thank you, Shane. So it is important to make the disclaimer that's noted at the bottom of this slide is that we don't actually know what the newest iteration of the moratorium says. So on Thursday, I think it was, Governor Inslee did indicate he was going to reissue or extend the moratorium, but it sounds like there are some changes. We just don't know what those are yet. I've heard through the grapevine that they're minor, but we're not privy to that yet. So just keep in mind all of the information that we're providing tonight is based on that most recent draft that we have access to, the 2019.3 draft issued on July 24th. And so I would just encourage you, if you have legal issues moving forward or have clients that have those issues, to try to find the most current draft once it is issued. And it is extended, I think, like Shane said, until the end of the year, so December 31st at 11:59 p.m. And that date lines up with the CDC moratorium expiration as well. Shane, do you mind clicking the next slide? Thank you. So we thought it would be helpful to talk about who's covered by Washington's moratorium, just because it is a little more extensive than I think folks would assume. So it covers some less traditional tenancy and living situations. I outlined the more commonly understood, situations that people are facing, including, renting an apartment, a house, or a room. Mobile home tenants are also covered, but also people that are staying in hotels, motels, places like Airbnbs, long-term care facilities are also explicitly mentioned in the moratorium, as well as RVs and camping areas. And so folks that are in those situations can also assert protections under Washington's eviction moratorium specifically. And the other thing that I think people get confused by, and I've seen come up in cases, are situations where the lease has actually expired, or there is no lease, it's a verbal lease. All of those situations are covered. And so if you have tenants whose leases, or if you are a tenant whose lease has expired during the effective period of the moratorium, all of the provisions still apply in terms of the bar on eviction. And I think I covered everything. Thank you. The other thing to keep in mind is there are 3 major exceptions to the eviction moratorium in Washington. And so they are those 2 60-day pieces related to a landlord moving into a property, so to occupy themselves, or selling a property if they decide to sell the house or unit. The other exception to the ban, which means that landlords can evict or file an eviction in these cases, are if they allege a significant and immediate risk to health or safety of others, or some sort of safety risk created by the tenant. The thing I would sort of keep in mind is that they do have to allege that threat with particularity. So if you just have a landlord that files sort of a bald assertion in a pleading saying there's a safety threat and there's no documentation provided, or there's no specificity as to what happened, like no police response, that is not an appropriate use of that exception. The other thing that I've seen happen or seen come up when I was volunteering with HJP was situations where they use the person's mental health issue as they classify that as a health and safety risk. And I think a lot of times that's going to constitute an abuse of that exception. And so I would just encourage, if you're a tenant who experiences, is served with an eviction complaint or experiences a threat of exclusion or eviction on that basis, to talk to an attorney if you can, because it's just a thing to sort of be mindful of. They may be abusing that exception and you may be able to fight back. And then we kind of just wanted to cover some things to keep in mind that are outlined in the moratorium that are not allowed. So even the threat of eviction does constitute a violation of the moratorium for non-payment of rent. And so a lot of people think, you know, it has to go through the full process. I have to be like served with pleadings or something like that for it to constitute a moratorium violation. But even landlords threatening tenants related to an eviction does constitute a violation. So I just keep that in mind. And serving or enforcing any notice requiring tenants to vacate. And then there's a list of all of the notices that are applicable there. It's not an exhaustive list. And so there could be other ways that landlords are violating the moratorium or being creative in the ways that they're violating the moratorium. So keep that in mind, that there may be weird things on there that also count. They're also not allowed to charge late fees for non-payment or late payment of rent. Another one that I saw recently was new imposition of utility charges, which I would also say is an inappropriate violation of the moratorium. And so I think at large, yeah, again, if you can talk to an attorney, if there's some sort of new fee or raised rent or anything like that, definitely seek out legal help. The other thing you can do that we'll cover more in later slides is report it to the Attorney General's office as a violation of the moratorium, and they can sometimes follow up and talk to your landlord. More things that the landlord can't do. Charging rent when the tenant did not have access to or live in the unit because of COVID-19. So if you're in a situation where you did get sick and you are hospitalized, or there's for some reason didn't have access to your unit or home because of the pandemic, they cannot charge rent for that time. I haven't actually had that come up. I don't know if Shane has, but just a handy thing to be mindful of. They can't, like I think I said in the last slide, can't increase or threat to increase rent. Retaliation is a big one that I feel like is happening pretty consistently for a lot of our clients. Landlords retaliating after tenants are asserting that they're protected under the moratorium. I would argue this can look a lot of different ways. You know, it can be, I've seen them, like landlords cutting off certain privileges that were understood under the lease. Or privileges probably isn't the right word, but like, you know, use of parts of the property or something like that. So I would think broadly in terms of what retaliation can look like. And if it feels like retaliation from your landlord, I would encourage you to report it to the Attorney General's office. And there is an online complaint form in Spanish and English, and you can also call. The other thing that I just found out today, because it came up in a case, is they may be able to take anonymous complaints. They basically have said they don't guarantee that they can keep it anonymous, but they'll do their best. We have this come up for tenants that are undocumented or worried about the repercussions if their landlords are aware that they made a report. I wish it was easier to do that anonymous process, but it does sound like they'll do their best, but it's not guaranteed that it will stay anonymous if you report to the AG.
And Catherine, if you don't mind, I think I just want to jump in and
Sure.
add a couple of thoughts on those first 2 points. So two of these prohibitions, especially, so the first one, when it comes to landlords being prohibited from charging rent or other charges for a time during which a tenant did not have access to the unit due to COVID-19. I think probably what the governor was going for there was protections for like college students or anyone else who lives in seasonal housing. So if that applies to you, or if that's the situation of someone you're helping, I would just keep that prohibition in mind, because that, you know, if say some college students were going to move into an apartment, then COVID happened, they all had to go back home to stay with their families, and the landlord tried to charge them rent for that school period anyway, that could arguably be a violation of this provision. So that's just one thing to keep in mind. And then I've also seen a lot of questions about landlords increasing rent. So the language of, and again, this is the order from July 24th. We're anticipating a new one being issued at any time. So for the proclamation that was issued July 24th and lasts through October 15th, the language on rent increases is to me seems pretty straightforward. It just says that their landlords are prohibited from increasing the rent. So even if a tenant was served with a rent increase notice, just before that prohibition was put in place, I think arguably it can't take effect until the moratorium is actually over. So that's just one thing that I've seen come up a lot in questions is, my landlord was going to increase my rent before this started. Can he still do that? I would say the answer to that is no, not while the moratorium's in place, because when you look at that prohibition, it doesn't say that landlords, it just says they're prohibited from increasing the rent. That's it. It actually says more than that, but when you look at like the sort of the functional language in there, landlords are prohibited from increasing or threatening to increase the rate of rent. So that's just something I wanted to tack on there. And then so Catherine, do you want to keep going or do you want me to take over?
Either way, we can trade off. That works.
Okay. So yeah, this is, I think, this is a big part of this moratorium that is going to be important both now and potentially in the future. So this slide references a particular provision of the statewide moratorium under which when a tenant has been unable to pay rent as a result of the COVID-19 outbreak, that is the one that's the one particular qualification that tenants need to be aware of. In order to be protected by this provision, the inability to pay rent has to be related to COVID-19. So it doesn't have to mean that a tenant was actually laid off or actually got sick and couldn't work. I think that it applies a little bit more broadly than that. There just has to be some connection to the COVID-19 outbreak in order for this protection to apply to a tenant. And if that is the case, then landlords are prohibited from treating unpaid rent as an enforceable debt. So they can't attempt to collect it through a collections agency. They can't threaten to try to collect it. They can't try to file an unlawful detainer action, which is the actual eviction lawsuit. They can't try to get it through any other type of judicial action, with one exception. And that exception is that the landlord can demonstrate by a preponderance of the evidence. Preponderance of the evidence just meaning, more than half, basically. So 50.1% of the evidence indicates that the landlord did offer this to the tenant. And that is a reasonable repayment plan based on the tenant's individual financial health and other circumstances. So if the landlord can show that they offered that repayment plan and the tenant either refused or failed to comply with it, then at that point, the landlord can try to collect the unpaid rent. There is a little bit of vagueness in the way this is written as far as whether it will continue to apply after the moratorium expires. Everything I've heard is that was Governor Inslee's intention, was for this protection to go on into the future, even after this moratorium expires. However, just going from the way that the proclamation is written, the language does not say that. So that's something to be aware of, is this protection is certainly in place during the moratorium, but as to whether it will continue to apply and continue to protect tenants after the moratorium expires, that is a little bit more up in the air. It's unfortunately just not written explicitly into the text of the governor's proclamation, despite the fact that it seems to have been his intention. So I think that more or less covers that provision. So as far as whether a tenant should enter a repayment plan with their landlord, I think it's really important to keep in mind that the moratorium requires that the terms of the repayment plan be reasonable in specifically related to your circumstances. So it's very important that a tenant not enter into a payment plan that they know that they can't afford. And because of that language where whether or not a repayment plan is reasonable is based only on the tenant circumstances, it does give you more leeway to go to your landlord and say, you know, look, I can't agree to these payments starting right away, but I can agree that once I have a job, once I have steady income again, I can start repaying X amount of dollars every month until it's paid off. And what I've heard from the Attorney General's office is they consider that to be a reasonable repayment plan. So that is just something to keep in mind if your landlord does approach you, or if a landlord approaches a tenant you are working with a repayment plan. Just keep in mind that reasonableness requirement to any repayment plan that the property owner or landlord offers to a tenant. Okay, and so one other thing we wanted to underscore is what the governor has issued is an eviction moratorium. It is not a moratorium on payment of rent. Rent is still due for tenants, and if it is at all possible for a tenant to continue to pay rent, or even whatever they can while being able to afford other necessities, it's really important to continue to pay that rent, because if a tenant stops paying rent because the moratorium is in place, that rent debt is still going to continue accruing every month. And once this moratorium ends, that tenant's going to be in a much worse place than they would have been if they'd been continuing to pay rent. Again, contingent on the ability to do so. So I think that's one thing we just really wanted to underscore, is that rent payments are still owed. It's just that the landlord can't actually take any eviction actions against a tenant, or, as we discussed, can't threaten to take certain actions against tenants. And I do think it's a smart idea to stay in contact with landlords. I know it can be difficult when you have no ability to pay rent and your landlord keeps asking where the rent money is, to just try to avoid those tense conversations altogether. But if a landlord is coming to a tenant and saying, do you want a repayment plan? Let's work on a repayment plan. I do think it's going to be important to at least engage with that landlord in good faith, because I would be worried about any sort of lack of communication or refusal to work with a landlord being then used as proof of, you know, a tenant refusing a repayment plan, something like that, right? Which then triggers that exception to that protection and allows the landlord to try and enforce that debt, that unpaid rent, as a debt. So I think that's just one thing we wanted to make a note of. You know, all things being equal, it would be best for the tenant to continue to engage their landlord in writing. It would be preferable, just so that you have a written record of these communications. And yeah, I think just being, and again, this will depend on any given tenant's relationship with their landlord, right? Some tenants are not going to have a relationship with their landlord where they will feel comfortable being upfront about their financial situation. But to the extent that they can do that, I think it could be beneficial to be able to say, you know, look, we've been trying to work things out with my landlord. Here's all our communications in writing. We still haven't gotten to a reasonable repayment plan, but I've been working with them. Like, it's my opinion that that would look better if this potentially does get to the point where the landlord is trying to push forward an eviction. That would look better than if a tenant just ignored all attempts at communication from the landlord. So the next thing to point out is if a landlord is violating the moratorium, the Attorney General's office is responsible for enforcing it. It is criminally enforceable, and a complaint form is available online. We've provided the link here. So I would, and again, Catherine kind of touched on concerns, if a tenant has particular concerns about being identified by a landlord as having made this complaint, or if they're worried, if a tenant is undocumented and worried about giving their information to a state agency, I think those are valid concerns. If they don't apply, though, I would encourage tenants to not be shy about filing a complaint. I've heard that the Attorney General's office is pretty responsive about either responding to those complaints, or if the landlord's behavior really does violate the moratorium, then you could have someone from the AG's office call the landlord and basically, inform them of their violation, tell them to stop, doing that behavior, basically. So I do think it's worth a tenant's time to make use of that and file a complaint if they believe that their landlord has been violating the moratorium. So let's see. And then now we're kind of getting more into things that are always illegal. These are more violations of state law that is in place under the Residential Landlord Tenant Act. So landlord lockouts, otherwise known as self-help evictions, where a landlord just comes in, changes the locks, or basically kicks the tenant out without a court order. That is always illegal. If that's something that has happened to you or someone that you're working with, get an attorney involved as soon as possible. Then we have utility shutoffs, tossing personal belongings out of the property unless it's a case where the tenant has abandoned the property. That's a different situation. And then there also are retaliation provisions built into the RLTA that can serve to protect a tenant whose landlord retaliates after the tenant asserts their rights under state law. So Catherine, do you want to kind of jump in and talk about some city by city protections?
Sure. So we just wanted to make note, and I know Shane touched on it earlier, that there also may be local level protections that apply depending on where you live. And so it's just important to keep that in mind. And as always, hopefully be able to talk to an attorney about which ones might apply. The Seattle Municipal Code in particular is very protective. And they also have the other thing that we didn't put on the slides is the Seattle Department of Construction and Inspections, SDCI, is a really good resource for Seattle tenants that are experiencing, it's quite a range of issues really, but I would say generally if you're experiencing what you think might be a violation of municipal code or of state law, to get in touch with them. I've had really good experiences on a couple of my cases with SDCI issuing notices to property owners and landlords, asking them to remedy anything, ranging from like leaky pipes that aren't being repaired. Habitability issues have come up. Also, they have gotten involved where the house, like the notices that have been issued to tenants for the sale of a property were not done properly, and SDCI reached out to the landlord to issue a notice that they had issued the wrong notice. Sorry, that was a confusing sentence. But that's a really good resource in Seattle for actual enforcement. I have found once you're outside of Seattle, we don't really have the equivalent of SDCI. And so The other areas still have ordinances though, so I would keep that in mind. I'm not an expert on the minutia of all of them, and they are probably not all listed. I just threw the ones on that came to mind. Some of these are relatively new, but they include things like bans on certain kinds of rent increases. And basically the idea behind the just cause eviction ordinances is that you can only evict for certain reasons. And so they're outlined within the content of those cities' municipal codes. And so you should be able to find it. I think one or two of them might be so new that they might not be codified yet. Shane, if you know, you're welcome to jump in. But yeah, that's sort of the general overview. And I know some other cities are trying to edge closer to that, like Issaquah. And there may be, yeah, I don't know, Shane, if you have any thoughts there. There may also, I know there are folks on this call that are very knowledgeable and are on top of the legislative developments locally. But these are sort of just things to keep in mind when you're trying to assess what legal protections and potentially remedies are available to you, because I know some of them also include relocation assistance. I know Seattle's does, provisions around things like that. So it's just really wanted to sort of flag it for everyone to keep in mind.
Yeah, and if you don't mind too, I want to kind of contrast. So the four cities on the screen here, just to kind of get into a little bit of detail on the implications, the practical implications of a city having a just cause ordinance versus not having one. Basically, every other city in the state outside of the ones listed on the screen and any we haven't accounted for, I mean, these laws are being passed more and more frequently, which is really positive news. But based on our knowledge, these are the cities that currently have them in place. So what does it mean if you're a resident in a city that doesn't have a just cause ordinance? Unfortunately, then what applies is the state law, that Residential Landlord Tenant Act, again, with respect to specifically, I think the biggest implication is termination of month-to-month tenancies. In any other city in the state, if you are a month-to-month tenant, your landlord can terminate your tenancy just by issuing you with a 20-day notice. And so that to me is the biggest difference and why these ordinances are so important and why it's so important to be aware of whether or not the city that you're living in has a just cause ordinance. So I just wanted to kind of throw that on there.
That's really helpful. Thank you, Shane. We also just wanted to cover and provide some resources where people can get help, tenants can get help. And so as we've said, Shane and I both work for ELAP. He focuses specifically on the city of Kirkland. So if you're a Kirkland resident, he can provide legal advice and representation. And Shane also has a very handy rental assistance fund. So he actually has some money if you need it, which I unfortunately do not. But I have a bit of a broader service area. So I cover all of King County with a focus on South King County, and can also provide legal advice and representation. ELAP's main line is listed there, as well as both of our email addresses. And folks are welcome to just email us directly with questions. And if they're in need of any kind of assistance related to housing. There are also other housing legal aid providers listed. So Housing Justice Project is a good one. They serve a ton of people, I think largely in the Seattle area, as I understand it. And Tenant Law Center is also a good Seattle-based resource. Northwest Justice Project has offices all over the state. And so if you call, there's two separate lines, I think. If you call 211, you can get access to their Seattle-based office. And if you call their Clear hotline number, which we don't have on there, but you can find online, you can get referred out for help in other areas of the state. And then Washington Law Help is also just sort of a resource page. So there are a ton of tenant like self-help resources and information about the state of the law and housing law that can be really helpful if you're proceeding pro se or without an attorney. Rent assistance. So King County has an eviction prevention and rental assistance program. I butcher it every time I try to say it. And they basically have a weekly lottery. So your client, or you rather, would apply, and then every week they send out an email letting you know if you've been selected or not. And there are some benefits to being enrolled in that program if your landlord does agree to be bound by, they basically make landlords sign an agreement that they won't evict until the end of March of 2021. And I believe they have to agree to accept 3 months rent as satisfaction of like the full back owed rent amount. I don't know if Shane, I think that's right. And so there's also some additional benefits to getting into that program if your landlord agrees. United Way is another resource, and East Side for All is an organization that works with tenants. Basically, it's an organization that represents tenants on the ground and also is involved in some policy making efforts, as I understand it. And HopeLink is another one, which actually I heard today gave a bunch of money to one of my clients. So I think that's a good active resource. I know I've had a hard time sort of deciphering which organizations are out of money and which aren't. I don't know if Shane, you have your own money, but I don't know if you have an idea of who still has money in their pots. I know HopeLink is one of them. I'm sorry, my screen is having trouble right now. Salvation Army, LifeSpring, Catholic Community Services, another one, Bird Bar Place, and then Plateau Outreach Ministries. I haven't worked with all of those. Shane, do you have anything to add in that regard as to who's been helpful?
I do not specifically. I don't know if Chris is available to jump in, but I think he is a really good resource for that. I think
go ahead.
This is Chris from ELAP. I'm not going to turn my camera on, but I just wanted to say, someone just posted in the chat about Bird Bar Place. They're actually out of funds. So
Okay.
thank you for mentioning that in the chat. Many of these agencies, Multi-Service Center, HopeLink, I believe, still have funds, and so you can contact them. I'm also going to put my email in the chat if you wanted more information about some of the other various places that may have a pot of money as well.
Okay, thank you, Chris. Yeah, and then so just the last thing on this slide, advocacy. If you're a tenant or you work with tenants or you just are interested in housing issues, tenant protections, and you're interested in seeing more robust protections put in place, there's some really good organizations doing that work in Washington. The Tenants Union of Washington and Washington Community Action Network are both very active on the policy front. So that's one potential avenue for getting involved. And then also just sort of the basic, almost cliche, talk to your representatives, get involved with your city council members, especially if you're in those cities that do not have just cause ordinances or might not even be considering one. I think that's a really good opportunity for advocacy. So we've built in plenty of time for questions. I am going to stop sharing my screen, I think, and we can just kind of focus on some Q&A if that sounds good to everyone.
Great, so I'm gonna just pull the questions that we've seen in the chat box here on the Zoom, and I see Sydney. Hi, Sydney. So Sydney's asking if landlords can still raise rent on a unit for a new tenant that's signing a new lease. I'm interpreting that as a unit that was vacant during COVID and rent was increased. Sydney, is that correct? Okay, thanks. So can rental increases happen during the COVID pandemic?
I am kind of thinking, so if we're talking about a unit that is already vacant, that a tenant is moving into, that is a brand new tenancy, I don't know that that necessarily fits within the prohibition on rent increases. I think, and Catherine, please weigh in, but I think I might need a little bit more info on the specifics there. I think if it were someone who was already on a term lease and the landlord's trying to renew and raise the rent, I think there's an argument that that's prohibited. But if it's an entirely new tenancy, new tenant moving into a new unit, it gets a little hazier for me on that.
Yeah, I was curious if you're saying, is it you haven't signed a lease yet and they like offered one rental amount and then changed it, or you've signed a lease? Because if I guess I think this is consistent with what you said, Shane. I think my interpretation, if you signed a lease and then they tried to increase the rent, I think that would be impermissible under the moratorium.
Okay, Sydney just entered some clarification. So previous tenant lower rent and the lease ends. So a new tenant comes in. So essentially, asking for a higher rent for the same unit during the pandemic.
I think that might be permissible. I don't know what you think, Shane, because I feel like if it were the same tenant and they raised rent, I think that would be barred. But I feel like if it's a whole new tenancy and you're signing a whole new lease, then I mean, it sucks for sure, but I think it would be permissible.
Yeah, that's my thought as well, unfortunately, without some sort of connection to the previous tenancy, even as like someone who's on a sublease or something. I think that's just a different scenario, unfortunately, and not one that fits neatly under the rent increase prohibition. So I'm seeing we also have a question about retaliation, whether retaliation has to be against an individual. I don't think it necessarily does, and I'm kind of just leafing through the proclamation from July to find the retaliation language. But I think as long as it's tied to some sort of action that a tenant took to assert their rights, either under the moratorium or under state law, and then retaliatory action was taken, as long as it also applies to that tenant who asserted their rights, I would have trouble concluding that the retaliation protections have to be against just that one individual. I mean, because, thinking about it, that individual is included under retaliation against, like a whole building or something, presumably. I don't know, Catherine, do you have any thoughts on that?
Yeah, I would encourage reporting it. I mean, I know, because I think in a few cases, the AG has actually dealt with whole complexes. I think we were talking about that, Shane, last week, if my memory is not completely failing. And so I would definitely encourage, I mean, I think the more you can get on their radar in terms of those like sketchy landlords and bigger landlords, the better. That would be my thought.
Yeah, and just to follow up on my thoughts there. So the provision in the proclamation, with again the caveat that we're expecting a new one every time, we don't anticipate major changes, but I do want to clarify that the language I'm reading is from the governor's proclamation from July. He should be issuing a new one anytime that's going to extend the moratorium. But with that said, so when you look at that language, it says that landlords are prohibited from retaliating against individuals for invoking their rights or protections under the eviction moratorium, essentially, or any state or federal law. So in that sense, if a landlord is retaliating against an entire building, that's still retaliation against that individual as well. So I definitely think that still would be a violation.
Okay, I see Chris has asked, what can you do as a renter if you live in a city that doesn't have a just cause eviction ordinance?
Go ahead, Catherine.
I was just going to say, reaching out to some of those organizations that we listed. So Washington Can, Eastside for All, I feel like I'm missing one, but reaching out to those organizations, because I know they're sort of mobilizing to organize tenants and advocate for that in the places where they don't yet exist, would be my initial thought. Shane, I don't know if you have more to add.
Yeah, definitely. I definitely agree with that. And then kind of like I remarked on briefly, also getting involved on an individual level with contacting city council members and just emphasizing the need for these protections, the just sheer amount of tenants who are struggling with paying rent right now and who could potentially lose their homes when this moratorium lifts, just without any just cause other than potentially having not paid the rent. But yeah, I mean, I think you have sort of the groups that you can get involved with, and then just on an individual level, staying in touch with your legislators, city council members, state legislators, federal legislators. I think that's a really important component.
And Chris pointed out Tenants Union is the one I missed. And Washington Low Income Housing Alliance. You put both of those in the chat for people that are interested.
So, and we also do have it's like plenty of time for other questions, I think, while we kind of wait a little bit for some to come in. There was one protection that I think, Catherine, we didn't really go into detail on because it's such a new program, but the state is sort of county by county implementing mediation programs for eviction cases. So I believe it's rolling out to 7 counties in particular to start. King County will be one of those. And so what that is just going to do is provide tenants with an opportunity to enter into mediation with their landlord. It gives them a chance to get their landlord to sit down at the table, try to negotiate something that would work out, basically resolve the conflict without it having to continue on to an eviction action. I don't know, Catherine, if you want to share any thoughts on that.
Sorry, I was reading about the LifeSpring resources in the chat. That's really helpful, Karen. Thank you. I don't think I apologize. I didn't hear everything you said, but the mediation program, I think, is a way to sort of slow down the eviction process and stop it before landlords are able to file. So it's hopefully going to draw out folks' ability to stay in their homes for longer. But I think it's still pretty, I don't have a super clear idea of what it's going to look like in practice. I know HJP is the idea is that they will provide hopefully counsel to folks that are going into those mediations, as well as the other legal aid providers. And that'll be coordinated through the Dispute Resolution Center. But sorry if that's redundant.
No, not at all. Yeah, it's just something I wanted to bring up. My understanding is that it would be essentially a requirement that the tenant be offered mediation prior to the landlord proceeding with the eviction lawsuit. So yeah, kind of like you said, at worst, it'll delay the process a little bit, but ideally it gives the parties an opportunity to work out a resolution without having to go through the entire lawsuit process. So
yeah, sorry, that was a pessimistic answer, just because I think a lot of folks who are going into that are going to be really behind on rent. But ideally it actually works and you get a positive agreement out of the mediation.
And for folks on the Facebook live stream or on the phone here in the Zoom, I just want to shout out what Karen shared in the chat. LifeSpring, which is one of the rental assistance and support resources that we mentioned earlier in the webinar, is available only to Bellevue residents. So I think that speaks to kind of the different sections of resources that people have to navigate and jump through in order to try to, cobble together past due rent. And I might pitch over to Emma if there's any questions coming in from the Facebook live stream.
Sorry, I was muted. There isn't actually any comments at this time.
I have a question. So Shane mentioned the 60-day notice that landlords are required to give tenants during the moratorium if they want to occupy or sell the property. Where does the burden of proof lie? How can a tenant kind of verify that that's the landlord's intention? What's required from the landlord to verify that occupation or sale of the property is happening?
yeah, yeah, thank you for asking that. The landlord doesn't have to prove anything. Which is my personal biggest complaint with that provision. As long as the landlord provides written 60-day notice of their intent to sell or occupy, then they've met the requirement and can terminate the tenant's tenancy. So we'll see if that changes at all with the extension. Again, we still don't know, but yeah, unfortunately, there's no follow-up on the back end where the landlord's required to prove that they actually sold the property or tried to, or that they actually live there as their primary residence. So
Yeah, that's
Yep.
a good question.
Oh.
And I feel like, sorry, didn't mean to cut you off. It's definitely an area of concern. I heard, I can't remember which call it was last week, but somebody had said the landlord issued a 60-day notice and then promptly reposted one of the units in the home. So like, it just really demonstrates that that's a huge concern, and there's not any real enforcement piece right now behind that. And I think that Shane and I have also talked about that a lot. Like, we can tell you what all of your rights are, but the actual enforcement mechanisms for you to access are super limited, especially outside of Seattle, you know, because I think there's a concentration of both legal resources and their code enforcement is better. But yeah, just these general issues I think that come up oftentimes, there aren't great ways for tenants to actually execute on what their rights should be.
So in that instance, then a little bit of a follow-up, if someone saw their unit posted on whatever platform, you know, a week after they were issued that notice and the full 60-day timeline expired, so they had moved out, would you recommend them filing a complaint with the Attorney General's office at that time and just documenting everything as much as possible? Or
I feel like I would, because they're abusing the moratorium, and the AG is the enforcement mechanism for it. So
okay.
I agree. And it's also a way, you know, even though in that situation, it's highly unlikely that tenant's going to be able to get that housing back, still filing a complaint at least lets the state know, hey, look, this is what landlords are doing, right? Like this is one of the ways they're kind of getting around this moratorium. So I think it's worth it even in that scenario. If it's okay though, I kind of want to pick up on what Karen wrote in the chat there. You know, don't we need concerted collective action to keep people housed? 100% yes, absolutely. I think, like we mentioned earlier, I know Tenants Union, I know they have events. I believe there may have been one down in Olympia, or there was, I think, a phones app recently. So I absolutely think that getting involved in stuff like that is going to be really important, because like Karen points out, when you look at the data around what Washington tenants are going through, it looks pretty grim, especially for once this moratorium ends, because really, you know, it's a temporary solution. We absolutely need to be thinking about what the state is going to look like after the moratorium lifts, and you know, anticipating those issues. And I think that collective action is going to be a huge part of that. So yeah, thank you, Karen, for bringing that up.
So
Question.
yeah, go ahead.
Well, I was just curious, and this isn't necessarily legal, but like a legal question, but more so in the realm of like, you know, protecting renters and whatnot. But like a lot of folks are unemployed right now, and so I'm wondering, is there any like incentive for folks to rent to people whose income doesn't reflect, you know, their typical income over the past few months, since many people have lost their jobs to COVID, due to COVID?
Yeah, that's a good question. I think really that would need to be answered more on the landlord side of things, kind of like what is motivating them right now, which unfortunately I just don't have any personal insight into. I would imagine that, you know, lots of empty units, probably difficult to fill when so many people have lost their jobs, but definitely from the tenant side, that's something that I kind of grapple with a lot is when you're helping a tenant who, might have had no issue paying their rent before COVID hit, and now their only income is unemployment. What real options are there for housing? Which I think again gets back to the urgent need for pushing for greater protections to keeping people housed, because I do think we're going to be dealing with the long-term economic effects of this for quite some time.
Yeah.
Second what Shane said. That was a good answer.
I think you may have touched on this, but how about for renters whose leases have expired between, February and now, and maybe in their lease agreement, it automatically converted to a month-to-month agreement. What protections do they have if they're unable to pay rent, they want to stay in their unit, they want to establish a payment plan, but maybe what protections does a tenant have to essentially stay housed in the housing that they were in at the beginning of the pandemic, if they have some issue with non-payment?
Yeah, Catherine, do you want to take that one?
Sure. They would be covered under the moratorium. So if you said it was a lease that converted to month, or if the lease ended, they are still covered by all of the provisions that we've discussed. So they can access the benefits provided under the moratorium in full, regardless of the situation there. So I would just encourage them. And if they want a payment plan, going back to what we were talking about before, like they can contact their landlord and ask for a plan that is specifically catered to their financial circumstances. And I think Shane said this, I think a lot of times what landlords think is a reasonable payment plan and what tenants think is a reasonable payment plan is different. But from our end, we think, like I think he also said, advocating, for a payment plan that's contingent on getting a new job or getting unemployment benefits, that sort of thing is totally reasonable. And so I would just encourage anyone in that position to just keep all of those things in mind.
Yeah, definitely. And then for circumstances where a lease doesn't go to month, the protections do still apply. It's a bit of a stranger legal situation where your tenancy does terminate with that lease, but the landlord can't evict you for as long as the moratorium is in place. And I think arguably too, there's risk that the rent continues to accrue every month that the tenant is occupying that unit. But even though the lease ends, even if it doesn't automatically convert to a month, that tenant is still specifically protected under the eviction moratorium, and the landlord cannot take any of those prohibited actions against them or threaten to take those actions. I will say, if the tenant does continue to pay rent like normal after the lease expires, then I think arguably at that point you've got a month-to-month tenancy.
Just want to open it up to other folks here in the Zoom room, and maybe do a quick check-in with Emma if there's anything in Facebook Live. If not, I've got lots of questions, but I would love to hear other folks as well. Okay, I have a question. So I know that, there are agreements in leases about the way that you dispose of garbage, the way that you, store things on your balcony or porch and things like that. And so any violation of that can be counted as kind of a nuisance or something, and you might get notified by your landlord that there's some sort of nuisance violation. Is there protections that are built in? And this is, Catherine, kind of to what you were mentioning about the health and safety of others and how that might be an opportunity for the moratorium to, not offer protection to renters if they're creating some sort of nuisance or health and safety issue for other residents around them or for, themselves or folks in their household. So is there like a threshold of what that health and safety violation looks like?
That's a really good question. And no, there's not a threshold. And so I would, on the tenant side, I'd say it'd have to be pled with specificity and be pretty bad. Like they'd really have to demonstrate. It can't just be like the tenant is messy and leaves things out in a way that's upsetting the landlord. It'd have to be like a major, like they're causing raw sewage to seep through into somebody else's unit. I mean, I'm just throwing things out there. It's kind of hard for me to come up with on the spot, but I think it would have to be a pretty dire situation where the tenant was directly causing, safety, like environmental hazards for other tenants. And so I don't think, just like traditional being like having a cluttered space or leaving things in places wouldn't, like, I guess what I'm trying to say is something that might constitute a lease violation often will not rise to what is necessary to allege a health and safety concern. I would say it has to be pretty severe. I don't know if you have anything to add, Shane.
Yeah, I'll just add, so referring to the language that is in the moratorium, that in this case, health risk has to be significant and immediate. So if the landlord is not able to attest that both of those qualify, that the risk is both significant and immediate, then it's not, to me, it's not going to meet that threshold. However objectionable it may be to the landlord. So, and I also see a question from Sydney around requesting payment plans where the tenant is not paying back the full rent just as much as they can, and then having the rest forgiven, and then follow up whether the landlord could come back for that unpaid rent later. Starting with that first one, yeah, I mean, the landlord and tenant can have pretty broad latitude to negotiate a resolution, right? At that point, you're talking about two parties coming up with an agreement. They can agree to a lot of different things to resolve that situation. I would say as long as that's in writing, and I would encourage any tenant who's trying to negotiate with their landlord to at least get an attorney to look over that agreement if possible before signing on to it. So, reaching out to ELAP, reaching out to the Housing Justice Project, Tenant Law Center, all those resources we went over earlier, just to be able to get an attorney to review the terms of it, to make sure, everything is to make sure that the terms basically, first, the tenant is agreeing to what they want to agree to, and then two, that there isn't anything the tenant may have overlooked in that. So that was a long answer. Short answer is yes, a tenant could absolutely request that. Whether the landlord will agree to it is going to be a different matter, and I would argue that's going to be the hard part, is getting the landlord to agree to that. And then, so for the second question, if
Can
you
I jump in, Shane? Sorry.
Yeah, go ahead, Catherine. Sorry.
I have specific thoughts based on a case I worked on. The reason it would also be helpful, I think, to have attorneys looking at those is you may have landlords proposing things that are unenforceable. And I think at the end of the day, if the tenant, were to pursue it legally, they would figure out it's unenforceable potentially. But I think avoiding having unreasonable language in the agreements at the outset is important. Like I had a case where they proposed that my client waive all notice protections under the proclamation and under the Seattle Municipal Code, and that's not a reasonable proposal. Like they can agree, to waive certain notice requirements under those things, but there's a section of the RLTA that says that they're waiving certain things is considered unenforceable, and I think just keeping in mind that they may ask the tenant to waive, in exchange for money or whatever the thing that the tenant wants is something that they shouldn't necessarily waive. So sorry to interrupt you. That was just the point I wanted to make.
No, not at all. Thank you for jumping in. So yeah, the second part of that question, can the landlord then come back for the unpaid rent later? Not if you have this written agreement. If you have a written agreement that's signed by the landlord and the tenant that says the landlord is waiving the rest of that rent, that's an agreement between the parties, provided you have, and again, this is why it's important to get an attorney to look over it, because there are provisions that you could add to an agreement like that specifically states that it's, an enforceable contract, that you can, pursue it in court if one party breaches, you know, so that those are the kind of things, like that's why it's important to get an attorney to look over it. But yeah, if you have that written agreement, the landlord can't then turn around and say, okay, where's the rest of the rent? If a landlord does try to do that, that is why it's so important to make sure you have a copy of that in a place where you will remember where it is, where you will have it handy, just in case you need to be able to prove like, no, look, we have this written agreement that we both signed that you said you were going to waive the rest of the rent. So, you know, I don't know what you're saying, trying to get the rest of the rent. I don't owe it anymore because you signed this agreement. So I think, yeah, I just want to emphasize if a tenant does get an agreement like that, make sure the tenant has a copy of it, keeps it safe, because if a landlord tries to pull something like that, that document is going to be really important. Okay, yeah, so that follow-up, if the landlord tries to turn around and say, you know, like takes it out of the security deposit, then at that point, I think tenant's either going to have to write a demand letter to demand that the landlord return that, you know, attach a copy of the written agreement with the landlord's signature, saying, you know, basically you violated our agreement, please return that, you know, or demanding return of that. If the landlord doesn't comply, then I think you're looking at potentially a small claims action, which applies to amounts in controversy that are, I believe, under $5,000. If it's above that, then you most likely need to get an attorney involved. But if it's an amount lower than that, then I think primary option would be a demand letter to the landlord. Secondary would be small claims.
We've got a few minutes left. What other lingering questions you all have?
This is Karen Stutters. I'm not going to show you my face because I'm under the weather. But I have a question. I've already put a couple things in chat. I've been here 5 years. I'm an attorney in other states, but not in this state. But I've worked a lot on these issues. My concern that I see coming with over 250,000 people that are currently homeowners that have already been identified as unable to pay their mortgage, and over 180,000 renters that have been identified as not having been able to pay their rent. When the moratorium expires and we start evicting people, which I expect business people, landlords will do, the number of people experiencing homelessness is going to drastically increase. I am somewhat appalled that the legal community is split up in nonprofits, just like everything else here. So there's no central area to go to have the lawyers talk about problem landlords, to identify collectively within the state of Washington where the problems are, or for lawyers to work collectively together to come up with strategies to keep people housed. The whole setup is pro-landlord. So we know that. I've had to learn it here. I now know it. So everyone knows it that plays in this field. So what are people doing to collectively figure out how we are going to legally work together and share information and keep people housed in the state of Washington? Because I am just amazed. I mean, this is not speaking badly of any single lawyer or nonprofit, but the nonprofits have a mission statement. They have their independent board of directors. They have their own executive director, and they don't play well in the sandbox together. And that's real in this area. So, and that's across the country. It's just that we have so many, and I've never seen legal services divvied up by county and by nonprofits. So knowing that that's the lay of the land, do we already have existing networks that share information, that work together? Do we already have executive directors that routinely speak to one another about problem landlords, patterns they see of abuse? Or are we going to have individual tenants totally dependent upon going to a nonprofit that may or may not know what has already occurred. And so are we just waiting to increase our number of people experiencing homelessness? And I'm sorry for the rant, but I'm just amazed here. I continue to learn here.
Yeah, the rant is very fair. I think both Shane and I probably would agree. Yeah, I agree that services are fragmented. I think within providers, we try to stay in communication via like listservs and meetings. There are lots of meetings. We try to be on those meetings together to discuss common problems. Shane, feel free to jump in and add to this because I've been in this position for a shorter time. So I'm still familiarizing myself with this legal community, but I do think there are efforts to collectively, share resources and talk about ongoing litigation and talk about how to support tenants during this time. But I do agree, particularly from the tenant side, trying to access legal services, I think there are a ton of barriers, and I definitely don't disagree with you. And it's something that I think we do need to all do a better job of addressing. So I think those are really good points to make, particularly during COVID, when there are more barriers inherently to accessing the courts and again to legal services. Shane, I don't know if you want to hop in and add more.
Yeah, no, I'll just say that, excuse me. I appreciate your comments, Karen. I think it's really important. And I think it's really important for, us as attorneys too, to not lose sight of the fact that we need to hold ourselves accountable and make sure that we are doing that collective work and staying in contact with each other, because everything is fragmented. And I don't have experience from other states to compare it to, but what I have heard is that this infrastructure for specifically tenants issues is fairly underdeveloped compared to some other states here in Washington. There isn't like an organized tenants bar that we can go join as attorneys or get involved with. I will say Northwest Justice Project, our statewide civil legal aid organization, they do a lot of good work keeping in contact with attorneys who are involved in these issues, coordinating certain actions on that front. But I absolutely agree with you, and I absolutely can appreciate that it can often be frustrating for a tenant who's trying to access services to get bounced around from one organization to the other and not know who can actually help them. I've definitely had that concern and frustration expressed to me from clients who or it makes it that much harder to access services. And to your point, Karen, these services are going to be more and more critical as we move forward, especially if we're not able to get some sort of solution or statewide legislation that is put in place to address what I think will almost certainly be widespread evictions and homelessness once the moratorium eventually lifts. So yeah, I mean, to your point, Karen, I absolutely hear what you're saying, and I agree. There are efforts underway among attorneys to keep in contact with each other, but as far as things like problem lists of landlords, that sort of like information sharing, I think that's the infrastructure that is still pretty underdeveloped in Washington as far as coordinating efforts on that front.
I think we might be just about at time. Karen, thank you for those comments. I know that some sort of database, especially for renters to be able to access, to just see interaction with landlords, history, fairness, is something that's crossed my mind as a renter in this state. And I think that it would be a really valuable tool. I can expect there'd be quite a lot of opposition. I'm not sure that's exactly what you were saying, but that's just something that could be quite helpful for folks when they're making the decision about who they're renting from. And a huge thank you to both you, Shane, Catherine. I know Chris, I think, might have had to jump off. We've got the storms knocking down trees. Emma, for all of your coordination of this event. We're going to post the recording on our website, and we'll share it out with folks that registered for this as well. So anybody that wasn't able to join us tonight will be able to access this information. And just thanks to everybody for joining us and for ELAP for all the work you do. And Sydney, is so great to see you. And I hope that everybody has a fabulous evening. Please join us for some other Affordable Housing Week events if you are able. You can access those. It looks like Emma just dropped a link in the chat on the Housing Development Consortium webpage. And we will be very excited to see you running throughout the week. So have a wonderful evening. Thanks so much for joining us, and thanks for all the valuable information. ELAP.
Thank you, everyone.
Thanks, everyone.
Yeah, thanks, Shane and Catherine. Bye, everyone.
Bye.